Hello everyone, this is Urvashi Chauhan. Welcome to another episode of Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. Starting with the most important update for today from the Supreme Court hearing on Manipur violence. A bench comprising CJI D.Y. Chandrachud, Justice J.B. Pardiwala and Justice Manoj Mishra today continued hearing a batch of petitions relating to Manipur violence. On the last hearing, the bench had slammed police investigation, noting that the FIRs were registered several days after the occurrences and that the arrests had been very few. The Manipur DGP today was personally present before the court as per the order passed last week. The Supreme Court said that it will pass a slew of directions in relation to the Manipur violence cases to restore a sense of faith in the rule of law and to build a sense of confidence. Further, the court said that a committee shall be formed to look into relief, remedial measures, rehabilitation measures, and restoration of homes and places of worship. The committee will be headed by Justice Geeta Mittal, former Chief Justice of Jammu and Kashmir High Court, and will consist of Justice Shalini Joshi, former Judge of the Bombay High Court, and Justice Asha Menon, former Judge of the Delhi High Court. As regards investigation, the court noted that Centre had decided to entrust 11 FIRs relating to sexual violence to the CBI. Further, the court will also include 5 officers from rank of at least Deputy Superintendent of Police, if not SP, drawn from other states. The court will add one more layer of security by appointing one officer to oversee the CBI investigation, who will be reporting back to the court. Also, as regards the state police investigation, the court noted the statement by state of Manipur that it will constitute 42 SITs to look after cases which are not transferred to the CBI. To read about the courtroom exchange and other details, you can visit our website at livelaw.in. The next important update is that Congress leader Rahul Gandhi's Lok Sabha membership has been restored today. As you know, last week the Supreme Court had stayed his conviction in the criminal defamation case over why all thieves have Modi's surname remark. The apex court noted that utterances of Rahul Gandhi were not in good taste and that a person in public life ought to have been more careful while making public speeches, but at the same time, his disqualification was affecting his electorate, which elected him in the constituency, and also the fact that no reason had been assigned by the trial court to award maximum sentence. So, the bench accordingly had stayed the conviction. The Lok Sabha Secretariat today issued a notification restoring his membership. Rahul Gandhi represents Wayanad constituency from Kerala in the Lok Sabha. He has inter alia maintained that he had no malified intention nor any intent to defame the complainant. For your information, let me tell you that as per Supreme Court's judgment of 2018 in the case of Lok Prahari versus Election Commission of India, once the conviction of an MP or MLA has been stayed by the appellate court, the disqualification under Section 8 of Representation of People's Act will not operate, and this, in a sense, leads to the revival of the membership. And now coming to an update from the Supreme Court on the Senthil Balaji matter. The Supreme Court bench comprising Justices A.S. Bopanna and M.M. Sondaresh today dismissed Tamil Nadu Minister Senthil Balaji's plea challenging the custody by the Enforcement Directorate in the Cash for Jobs scam. Also, the court has granted custody to ED till 12th of August. Thus, the court dismissed the petitions filed by Balaji and his wife Meghala challenging Madras High Court's judgment which held that the ED was entitled to take Balaji into police custody. The court also rejected their pleas that the ED's arrest was illegal. You already know that Balaji, the Minister of Electricity, Prohibition and Excise, was arrested by the ED on 15th June this year in connection with cash for job scam relating back to his term as Transport Minister during the 2011-16 AIADMK government. The arrest came after an order of the Supreme Court in May, which set aside a direction of Madras High Court staying the proceedings in the money laundering case against him. You also know that he was denied interim bail by the High Court but was allowed to be shifted to a private hospital after he complained of chest pain. Then, a division bench of the High Court delivered a split verdict in the habeas plea filed by him, and when the matter was referred to a third judge, he ruled in favor of the ED. Balaji had then approached the Supreme Court, which had reserved its judgment last week and today ruled in favor of ED. Lastly, the two-judge bench of Supreme Court also referred the judgment in Anupam Kulkarni case, which held that police custody is not permissible beyond first 15 days of remand, to a larger bench for reconsideration. And now an update on the caste-based survey in Bihar. As you know that Patna High Court delivered its verdict last week, upholding the survey as perfectly valid, initiated with due competence, and dismissed the petitions challenging it. The High Court concluded that the state's contention could not be brushed aside, that the purpose of the survey was to identify backward classes, scheduled classes, and scheduled tribes with the aim of uplifting them and ensuring equal opportunities to them. Multiple petitions have now been filed in the Supreme Court challenging the decision. The petitioners have inter alia reiterated before the top court that the exercise being carried out by the Bihar government amounts to a census and that only the union is empowered to carry out. The petitioners insist that the Patna High Court erroneously dismissed the writ petition without taking into consideration the fact that the state government lacked the competence to notify a caste-based survey. Today, the Supreme Court adjourned the hearing of one such petition filed by an NGO, Ek Soch Ek Prayas, against the decision of Patna High Court on account of another petition challenging the same judgment not being listed today. A bench of Justices Sanjay Khanna and SVN Bhatti also denied the request by a council for a status quo order. The matter will be relisted on 14th August now. Stay tuned with us. The Supreme Court today refused to entertain a petition seeking judicial probe into the alleged voice clips of Tamil Nadu Minister P.T. Rajan, in which he had allegedly made remarks about the amassing of wealth by the family of Tamil Nadu Chief Minister M.K. Stalin. So in April this year, Tamil Nadu BJP Chief K. Annamalai released an audio clip which he claimed contained the voice of P.T. Rajan making allegations against Stalin's family members and the DMK leaders. Following the release of tapes, P.T. Rajan had issued a denial and said that the tapes were fabricated, refuting claims of having made the remarks. In May, the Tamil Nadu Chief Minister M.K. Stalin had filed a defamation suit against Annamalai for making corruption allegations against him and his cabinet colleagues. It accused the BJP chief of resorting to political ill will. In this regard, a petition was also filed in the Supreme Court. The petitioner, Pranesh Raja Manikam, appearing as party in person, submitted that T. Rajan was changed as the finance minister due to the voice clips. He questioned that if it was not his voice, then why was he changed? And that he, as a voter in Tamil Nadu, was entitled to know the reasons behind the decision. He also contended that a judicial inquiry was necessary. But the bench comprising CJI Chandrachud and Justices J.B. Pardewala and Manoj Mishra clearly stated that there was no actionable material and that an inquiry could not be commissioned on the basis of an audio clip. Calling the petition to be an absolute bogus, the bench dismissed it. You must be well aware of the violence that broke out in Haryana's Nadu district last week. The situation remains critical in subdivisions of Gurugram after communal violence erupted between a group of young men and Vishwa Hindu Parishad during a religious procession in the Nadu district that claimed 6 lives and left more than 20 police personnel injured. According to the police, the fight started after Vishwa Hindu Parishad's Bridge Mandal Jal Abhishek Yatra was stopped by a group of young men near Nadu and stones were pelted at the procession. Some police vehicles were also damaged and cars were set on fire during the communal clashes. Last week, when the court was hearing a plea against the rallies and protest marches organized by the VHP and the Bajrang Dal in the wake of the communal violence, the court had issued a call to action to stakeholders to find an enduring solution to the problem of hate speech. Highlighting that the difficulty lay in implementing and executing the law on hate speech, Justice Sanjeev Khanna had suggested appropriately sensitizing the police forces to ensure that victims of hate speech could access meaningful remedies. Allegedly, demolition drive to raise the alleged illegal constructions has been ongoing in Nadu since 3rd August without any prior notice to the occupants. Authorities have reportedly demolished several illegal shanties, temporary shops and certain concrete structures allegedly belonging to persons involved in communal violence. In a suo motu action today, the Punjab and Haryana court stayed the ongoing demolition drive. While issuing notice to the state government, the bench of Justice Gurmeet Singh Sandhwalia stayed the demolition until further orders. And now coming to the Madras High Court, which has suspended the order of imprisonment against IAS officer Pradeep Yadav and 2 others in the contempt case for failure to implement court orders while he was holding the post of Principal Secretary to School Education Department. Recently, a single judge had sentenced the condemners to 2 weeks imprisonment after ruling that the authorities had failed to comply with the order directing them to regularize the services of an employee. The single judge had observed that the authorities had only complied with the order after the notice was issued in the contempt plea and had thus committed willful disobedience of the court order. The court had also refused to accept the unconditional apology of the officials and said that if any lenient view was to be taken against such officers, it would send a wrong message to such government officials. But the division bench of Justice S.S. Sundar and Justice Bharat Chakrabarti of the Madurai bench suspended the sentence while hearing an appeal against the order of the single judge. In an update from the Delhi High Court, it today issued notice on a public interest litigation seeking removal or demolition of mosques, dargahs, mazars and graveyards allegedly constructed illegally and unauthorizedly at public places in the national capital. The plea has been moved by 5 individuals who claim that the tendency of constructing mosques and mazars at public places in Delhi is rapidly increasing day by day and that the authorities have failed to discharge their mandatory duty in dealing with the matter. A direction is sought on the authorities to take necessary action for demolishing or removing the religious structures in question which are raised or constructed at public places, pathways or highways. A division bench of Chief Justice Satish Chandra Sharma and Justice Saurabh Banerjee today issued notice and sought response of the Union Government through Ministry of Home Affairs, Delhi Government, Delhi Police, Municipal Corporation of Delhi and Delhi's Public Works Department. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us.